350 crores worth just to protect their clients if they're going to make incorrect and unfair submissions. Your Lordship, they must be hauled up and a huge amount of penalty must be levied against them for having misled this court this way. Man is incapacitated, man is unwell, he cannot work. It's incredible how he's able to have parties, how he's able to throw luxurious parties and even be dancing. He's not even divorced. He calls that woman his wife. Kindly see the photos. And that girl is his wife's child from an earlier marriage. He seems to call that child his own, throws the most lavish parties for them, is dancing and kissing this supposed wife of his. But they submit before this court that this poor man is incapacitated, unable to work. The 125 application, 1 lakh was granted. He moved, this honorable court stated he doesn't have a job, he has nothing. So therefore, Lordships passed an order stating, okay, we will make it 50,000, but 50,000 from the date it is due, deposit the entire amount, then we will hear the matter. That has not been complied with and therefore that order itself would have to be vacated. Heard learned counsel for petitioner. Learned counsel petitioner submits that he's paid a sum of rupees 40 lakhs towards maintenance till date up to the respondents. Submits that he is not in a position to pay the maintenance as of now. He has no source of income due to his incapacity and inability to work, and presently he is unemployed. All these aspects would have to be considered later on. However, for the time being, this court deems it appropriate to take up IA-4 for consideration. There shall be a stay of the impugned order dated 2010-2023. Passed in Criminal Miscellaneous 175/2010 by the first additional principal judge, subject to the condition petitioner pays/deposits a sum of 50,000 per month as maintenance to respondent 1 and 2 as against 1 lakh ordered by the Learned Family Court, and the petitioner shall pay the arrears of maintenance at the rate of 50,000 per month within a period of 3 months from today. Accordingly, IA allowed. If the amount is already paid, it shall be deducted. Now, this itself, Your Lordship, is not complained. As against that, he's paid 3 lakhs, Your Lordship. Now, subsequently, when it came before Your Lordships, we were not present. They have stated that man is incapacitated, man is unwell, he cannot work. If I just pass it on, it's incredible how he's able to have parties, how he's able to throw luxurious parties and even be dancing while they mentioned before this court that the man is incapacitated. Might I just pass this on, Your Lordship? And Your Lordship, he has been a marine engineer and in merchant navy. Merchant navy, at that point of time, he was earning 6 lakhs per month. Now he says, no, I'm not okay, I'm not. But they are running an institution that trains marine engineers and they conveniently put him as visiting faculty. The name of the company that they own is in the name of his parents' names. His younger 2 brothers, all of them put together, have 350 crores worth of property. He has a 19-year-old daughter, doesn't want to pay for her, but Your Lordship may kindly see, he's not even divorced. He calls that woman his wife. Kindly see the photos. And that girl is his wife's child from an earlier marriage. He seems to call that child his own, throws the most lavish parties for them, is dancing and kissing this supposed wife of his. But they submit before this court that this poor man is incapacitated, unable to work. 350 crores worth. Let him not pay anything to the wife. What about his 19-year-old daughter here when happily celebrating somebody else's child's birthday, calling that child his own? Your Lordship, somewhere we must draw a line where counsel will have to make submissions which are true and fact as they are ultimately officers of the court, just to protect their clients if they're going to make incorrect and unfair submissions. Your Lordship, they must be hauled up. And a huge amount of penalty must be levied against them for having misled this court this way. Let him be ordered to be present, then Your Lordship would know his present condition, even if he comes himself all strapped around. And now, Your Lordship, we also have a couple of videos as latest as now. Your Lordship would be able to see what all he's up to. The company's name He's running this supposed marine training is in the name of his father and mother. Visiting faculty, online we get all of this. Just to avoid paying for his child, he's saying he doesn't have a job.
I thought I was appearing for the petitioner, but the senior advocate seems to have, not all, prerogative is always there. But to make a submission that court has been misled, and that's very uncharitable, because I have come on no objection wakalat on the last hearing. The senior counsel also has been engaged for the first time in this matter. The counsel on record of the last time was somebody else, and brought to your lordship's notice the interim order passed by his lordship Justice Pradeep Yerur. And at that point in time, I brought this honorable court's notice that the arrears, if I have to pay the arrears, it amounts to 45 lakh rupees. And it's impossible for me to pay, and therefore I requested my lord to hear the matter on merits. Your lordship will kindly recollect, this is a case where interim order has been granted, interim maintenance has been granted by the court at the rate of 25,000 rupees per month. That interim order was in force for 10 years. I have complied with that interim order throughout. That interim order was challenged by me, as also the respondent before this honorable court. The interim order was affirmed. My petition was dismissed, their petition they withdrew. That order having become final, the family court now passes another order, a final order in 125 proceedings, awarding 50,000 rupees to my wife and daughter per month. 50,000 each. From the time the application was made before the family court. Your lordship may kindly recollect, this was the...
You're saying that it should be from the date of order.
It can only be from the date of the order. It cannot relate back to a date where an order is already passed and has become final. This was not the concept is one of, your lordship will kindly appreciate this section 24 and 25. 24 is interim maintenance during the pendency, and 25 takes effect from the date of the disposal of the proceedings. Similarly, 125, an interim application was filed. I understand if there was no interim order made, which had not been affirmed by this honorable court. Whereas an interim order has already been made, that has been affirmed in challenges by both the parties. Now, my humble submission is the family court could not have passed an order of this nature relating back to the date of the application. That was impermissible is my humble submission. And
Say on that subject.
no, I have one.
If that was the case, then even that interim order, he should not have misled. Interim order, there is a direction. Then he could have said that 50,000, when they brought down to half and said comply it on the entire arrears also, then they should have argued on that aspect.
No, on a procedural aspect, the final order that is passed for maintenance
Please.
shall be effective from the date of the order or from the date of the petition.
Date of the petition, your lordship, when the application is made.
Lord, may I read? Order for maintenance of wives, children and parents. If any person having sufficient means neglects or refuses to maintain his wife unable to maintain herself, his legitimate or illegitimate minor child, whether married or not, unable to maintain itself, or his legitimate or illegitimate child not being a married daughter, who attained majority where such child is by reason of any physical or mental abnormality or injury unable to maintain itself, or his father or mother unable to maintain himself or herself, a magistrate of the first class may, upon proof of such neglect of refusal, order such person to make a monthly allowance for the maintenance of his wife or such child, father or mother, at such monthly rate as such magistrate thinks fit, and to pay the same to such person as a magistrate may from time to time.
क्या अदालत को गुमराह करने वालों पर कड़ी सजा और जुर्माना लगना चाहिए? इस पर आपकी क्या राय है, हमें कमेंट्स में जरूर बताइए। कर्नाटका हाई कोर्ट की इस कार्यवाही में पत्नी की ओर से पेश वकील ने ऐसे सबूत सामने रखे जिनसे पूरा मामला ही बदल गया। नए साक्ष्य से यह साफ हो गया कि पति के पास करोड़ों की संपत्ति है और वह अपनी पहली पत्नी की बेटी के लिए आलीशान पार्टियां आयोजित कर रहा है, लेकिन दूसरी पत्नी और उसकी बेटी को पूरी तरह नजरअंदाज कर रहा है। ऐसे में पति द्वारा पहले किया गया यह वादा कि उसकी कोई आय नहीं है और वह काम करने में असमर्थ है पूरी तरह गलत साबित हुआ। पत्नी की ओर से वकील ने यह भी आरोप लगाया कि विपक्ष के वकील ने अपने मुवक्किल के पक्ष में अदालत को पूरी तरह गुमराह किया है और ऐसे वकील पर भारी जुर्माना लगाया जाना चाहिए। यह मामला अभी जारी है, जल्द ही हम आपको इसके अगले अपडेट से अवगत कराएंगे। धन्यवाद।